1770 CDB 1A, CEQA number ENB 2013-2592 MND. The address is 259 Southampton Drive. And as soon as our planning staff is ready, we can start talking about this one.
Commissioners, this is Kevin Jones from the LA City Planning Department, the city planner that is responsible for actually item number 5 that I would ask you to consider concurrently. It's for the, since what you have before you is an appeal of the actions from the zoning administrator's office regarding alcoholic beverages and a coastal development permit at this address of 259 Hampton Drive.
Okay, yeah, I did mention that. Yeah, we will do both. We will both together.
Correct.
And so let me just read that into the record. I already read number 4. Number 5 is DIR 2010-2932 SBP 1A. Related cases indicated there. The CEQA number is 2013-2592 MND. The address is still the same, 259 Southampton Drive. Thank you.
Commissioners, this involves my part, and by the way, my name is Kevin Jones, once again, the city planner that prepared the appeal report on a director's that references the director's determination on the project permit compliance done by another planner. There is also another planner here that is here on behalf of the zoning administrator's office, and that person.
Theodore Irving, I'm representing the Office of Zone Administration. I'm representing the ZA decision letter that has been appealed.
As far as what the director heard, it was a project, specific plan, project permit compliance review to change the use of a building containing a 1,042 square foot retail store area and 616 square feet of fast food takeout only restaurant area to a 1,658 square foot full service sit down restaurant. The project also includes the rooftop dining, the total approval for the restaurant service floor area, both upstairs and downstairs total shall not exceed 1,000 square feet in total area. The appellant is here and filed an appeal on the approval of the project permit compliance and the mitigated negative declaration. And with that, the planning department recommends that you deny the appeal, sustain the determination of the director of planning, and to adopt the mitigated negative declaration for the environmental impact report. The zoning administrator's office will then recommend the following.
Theodore Irving, Office of Zone Administration. So we're recommending that the appeal be denied and that you sustain the decision of the Office of Zone Administration as well.
I want to add some clarification for the public record that is also seems to be a challenge as a city planner that assumed the file from a previous a previous planner. What is in the staff report is the determination and were plans that are stamped Exhibit A as they were contained in the file that was given to me. It has come to our attention earlier this evening, like within the past 2 hours, that the zoning administrator's office and the mitigated negative declaration had a different set of plans that reflected the rooftop deck. And that is an inconsistency that I find very difficult and is confusing for the public and is confusing also for the commissioners. What we have been able to obtain are the plans that came from the zoning administrator's determination that shows service floor area on both the ground floor and the rooftop deck. But however, the language in the original determination indicates that the intent was to also approve the same plans that were reviewed in the mitigated negative declaration and in the zoning administrator's determination. What I've given to you and what you may do is that I know that there are a number of people that are very concerned about the continuity of records between various entitlement actions as they go forward. Part of the confusion is, as you can see in my staff report, where I say in 2010, the project permit compliance was filed, and subsequent to that, the law was changed, and an ordinance was adopted to change the municipal code, saying that if you have multiple approvals, you have to file them all at the same time. My original project permit compliance was placed on hold, and it was prepared by the previous, and it wasn't placed on hold by the previous planner. During that time, the multiple approvals ordinance came through. The applicant then filed for the other provisions of the entitlement, which included the alcoholic beverage permit and the coastal development permit, and in addition, later filed the environmental assessment form to assess all the environmental impacts for the revised project that had the 1,000 square feet of service floor area on the ground floor, and then in total with a rooftop patio. That was not well communicated in my appeals staff report. What I would ask you to do is to consider the merits that were outlined in the staff report. There is a request from the applicant. They provided us an extension of time to render a decision from the commission by the end of January 13th. I know that there are a number of people here that would like to provide their testimony regarding their appeal for you to consider. And I would, at the council office, particularly the deputy, Chris Robertson, has also asked that you also consider the testimony if you choose to accept testimony today, but to also consider maybe rendering your decision at a date to be prescribed later maybe at your next meeting, when you've had a chance to actually look at, and for us to concur that the plans from the zoning administrator's action should in fact be included in the original director's determination, as well for the project permit compliance. And with that, I can answer more questions for you.
Commissioner Donovan, so you're saying that there's inconsistencies between the ZA determination and the MND, and that the applicant...
No, it's just the plans.
Oh, okay.
It's just the plans that were submitted as part of the director's determination for the SPP. The ZA action and the mitigated negative declaration have the same plans.
Okay. All right. So then what you're asking for is that the applicant is asking that we defer a decision until a later date because...
Well, you could do that. However...
What's the reason to defer it?
Well, maybe not. Now that we have those plans ahead of you, what is part of the problem? What? Hold on.
Shauna Watson, Senior City Planner, just because this is kind of new information to me too. So one way of explaining it is simply that the director's decision, while it references an Exhibit A, that Exhibit A shows, attached to that is 600 square feet versus the 1,000 square feet that is part of the Exhibit A that the director's, zoning administrator's decision had, and that the MND contemplated. So the rest of this determination letter references 1,000 square feet. The Exhibit A is not consistent with that. An easy fix, were you to approve it, I don't even know, how the conversation is going to go today, would be to simply add a condition that the site plan be modified to reflect the rest of the decision in there. Again, if that's what you end up doing.
Okay. So I was just trying to get my head around whether or not there's been a request for a continuance, because I guess my druthers, I don't like to hear testimony and then have another hearing later on to render a decision, because then people, you have to go back and listen and refresh your memory, and I'd rather do it all in one time, one way or the other. So whether we do it all today or we do it another time, but I don't want to split up taking testimony between.
And with that, if you should consider after considering the testimony and considering the appeal points that are going to be presented to you, I would go along and I concur with the senior city planner's recommendation to revise site plan compliance conditions number 3.
Okay, well, is there any reason why we just can't go forward with
Sure,
the
you can.
with the hearing tonight and hear the testimony, and then any kind of adjustments we have to make in the paperwork, we can do when we decide whether or not the commission's going to sustain the appeal or not?
Correct.
Okay, all right. So given that, is there anything further you want to tell us about this particular project as the opening remarks?
As far as the project permit compliance is concerned, that the director rendered its decision on, while we do appreciate the points that they are raising with regards to the inconsistency of the public record, the efforts that they made, and we do appreciate the efforts that they made in trying to determine what the record should in fact have in it, and I do appreciate that. You will hear concerns about parking, you will hear concerns about noise. Please keep in mind that the mitigation of the M&D followed standard mitigation measures that are required for any restaurant that is near residential uses. So it would be the same mitigation measures that are throughout the city. The parking calculations would be based on whether or not the parking calculations are based upon the total 1,000 square feet of service floor area, so there isn't an inconsistency on that. It just provides options for the applicant to follow, which are fully allowed in the specific plan. It seems that based upon the appellant's point that they would like to have well-established parking amounts and methods of calculation and supply to be clearly delineated in the determination. However, the specific plan allows for various options to be used in the providing and/or calculation of parking amounts. And noise was the other one, but you do have the other major concerns that had to deal with the zoning administrator's action regarding the appeal, and with that I'll step aside, because my report only talks about compliance with the project, with the specific plan.
Okay, Theodore Urban, Office of Zoning Administration, as Kevin pointed out, his portion of this project specifically relates to the rest of determination, and that's with regard to the specific plan. The zoning administrator's action is 2 things: the coastal development permit compliance and conditional use for alcohol sales. And so the applicant or the appellant has challenged the approval of the coastal development permit primarily based on parking and access to public right-of-ways. So with regard to parking, the zoning administrator has deferred to the specific plan, because the specific plan is more specific in terms of its parking than a general code. And so it made no decision with regard to parking as it relates to the coastal development permit. That decision was deferred to the director's determination, and the specific plan approved the required parking as it relates to the coastal development permit.
Commissioner Howell, question if I may. Is the specific plan more restrictive or less restrictive than the coastal plan?
I'm going to say it's more specific. I don't know the details of the specific plan, but in general, you don't construct a specific plan unless you plan to make it more restrictive. So I defer to Kevin on.
Commissioners, the specific plan, the Venice specific plan, is more or requires more parking as it relates to the municipal code. So, as far as the coastal plan, what we're following and what we're required to follow is what's codified in the specific plan itself, in the Venice, because that's the implementing ordinance that we choose. But remember,
They have a coastal plan, that's correct.
Right, so the coastal.
but we use the Venice specific plan as an implementing tool and for the consideration of projects, and have been for several years.
So it's the same.
Yes, they should be the same.
So in terms of, because of its complying with the specific plan, the coastal development permit was approved, and the specific issue related to parking in the appeal was again deferred to the specific plan's approval of parking.
Commissioner Halper, again, what confuses me is why we are dealing with two separate documents and two separate plans. I know you wrote, it was an attempt to explain it. Unfortunately, the commission has had a limited time to really review these documents because of the holidays. We got the package with the restricted time to look at it. So I really didn't digest that. If you could help me with that, I'd appreciate it.
Oh, I'll attempt to do that for you. I'll do it. Okay.
In my staff report, it explains, and you'll notice the case numbers and how they were filed. The issue is that it was slightly confusing in that on June 29, no, I'm sorry, let me see. On October 26, 2010, the director's determination application for the project permit was filed. Along with that project permit compliance application, that project qualified for what was known as a categorical exemption in 2010. And the categorical exemption that was going along forward with that project permit compliance was 2010-2933. Subsequent to that, on June 29, 2012, the applicant filed for what is known as Zoning Administration 2012 1770 Coastal Development Permit and Conditional Use Permit. And then there was an environmental assessment also filed with that. Subsequent to that, and what happened is that they then later filed for an environmental assessment on August 2013 to prepare an environmental document that would cover all of these actions. What happened in the meantime is the multiple approvals amendment that is now part of LAMC 1236, projects requiring multiple approvals. That became effective in the middle of the projects and why they were placed on hold in anticipation of this ordinance that became effective May 20th of 2012. With that filing, or with that amendment that then said multiple approvals, joined them all to the extent possible, but we could not because we had a case that had been filed prior to that multiple approvals ordinance. So with the passing of the multiple approvals ordinance, they then filed for the alcohol sales and coastal development permit, and the EAF was filed to cover all of the actions at once. Yes, it is confusing.
Well, the reason I asked the question, I had written, for the benefit of my colleagues, I had written a letter to Ms. Weber, which I felt strongly that the bifurcation of the Coastal Commission and the city permissions was not a good idea. It's extra work and caused the public some issues. So I would hope that was not. I just don't do that. You're all here together. Yeah.
Sean Boston, actually I want to speak to that. We heard loud and clear, and I think we've seen a couple of examples of cases that bifurcated and offered a lot of confusion. So while this part of the application predated the multiple approvals ordinance, our attempt here, at least hearing the appeals together, are giving everyone a chance to take the project in and evaluate it in its entirety, although technically there are two different decision-making bodies that issued the initial determinations. So
It is confusing, and thank you.
Okay, all right, so let me see if I can conclude this portion of the zoning administrator's appeal. And so, again, they raised some issues about whether the coastal development permit was valid because of potential adverse impact to public access. And again, because the project was in compliance with the specific plan, which is the implement for coastal development permit, the zoning administrator found that the CDP made findings for the approval of the CDP. With regards to the alcohol sales, the applicant has raised some issues about over-concentration of alcohol sales in this area.
You mean the appellant?
I'm sorry, the appellant, I do apologize. The appellant has raised some issues about overconcentration and a lot of alcohol sales already exist in this area. As we know, this is a tourist attraction. It's a little different than your typical neighborhood. So it's very typical, as it is in Hollywood, as it is in downtown, to have a high concentration of alcohol sales because of this being a destination place. And so granting the approval of the CUB with the area exceeding the number of licensed alcohol permitted by the state, it's very typical because of its being a destination location. So on that basis, that's why the zoning administrator approved the CUB and we still stand by that approval of the CUP and ask that this commission uphold the zoning administrator's action of the CUP.
Commissioner Donovan, regarding the alcohol sales and over-concentration, did you know that the LAPD was opposing the CUB when you issued your determination?
The letter that I received from the LAPD came in after the determination was issued.
Okay, does it have any impact on how you feel about the decision?
Not how I feel about this. I'm supporting my zoning administrator's original approval of this action in September 18th. So it's up to you if you want to consider that information for LAPD. But at the time, that's not. We didn't get that information from LAPD at the time.
Now, am I correct in understanding that this restaurant was operating at this location illegally before this whole application process?
Yeah, there's some understanding about that, but what I would urge is that I think we can have the appellate can explain that, but there's some understanding that it was some illegal operation.
Okay, so in other words, they did not have a liquor license before.
I think it was as a restaurant they were operating illegally, not necessarily selling alcohol.
When they were operating the restaurant, they were not selling alcohol?
It's my understanding that we're not selling alcohol at the time.
Okay. And can you, with regard to doing the CUB, and you'll have to help me because again we've had some limited time on this. What kind of provisions have you put in there for review of the situation to make sure that they're good citizens and we don't have complaints, nuisance problems, things like that?
Yeah, okay, I understand. So I want to take you back to condition number 10 on page 2, in which we require that the applicant return to our office to file a plan for approval. And that gives us an opportunity to check in to see if there are good neighbors.
Okay, so you got basically, they have a 2-year window to show that they're not going to cause any problems.
Correct.
And is that, we've seen in other situations where there have been evidence of problems in the neighborhood where we've had shorter terms for this. Like a 1 year or is there any particular reason to go with 2 years as opposed to?
I'm not familiar with a 1 year. That would probably be an extreme situation. So in my experience with the department and with the office, it's been 2 years has been the minimum that I've seen.
Okay. All right. Any further questions from staff?
Commissioner Waltz-Morocco, on the heels of what my fellow commissioner was talking about, the approval of alcohol service, I'm looking at this report, and according to the State of California Department of Alcohol Beverage Control, ABC license criteria, 2 on-sale and 2 off-sale licenses are allocated to the census tract. Currently, there are 12 on-site and 3 off-site licenses in the census tract. Now, believe me, I'm the last one to count bars. I really am. But that seems like a lot. And I understand that this is a tourist area. I get it. But it's not a couple more, it's a lot more. So then the next paragraph I read is, okay, there's a lot of alcohol in this area. So that's okay as long as there's not a lot of problems, right? Well, in the next paragraph it says 539 crimes were reported compared to citywide average of 146. That's almost 4-fold. So the question is, I'm just wondering, how do you then use this and justify this when it's over the limit, which you could argue tourist area, but it's a proven problem area?
I do my best to defend the decision on this. Again, it's a tourist area, and so first of all, that number is a census tract number that's based on population. Okay, so based on that population, which we know this area is M1, And so it doesn't have the density you would find with the R4 zone or R3 zone. So the number in terms of population is going to be low. And it's skewed the number of alcohol permits that you're allowed to have in this area that's highly attractive as a destination place. So I think that's kind of where that number is thrown off. And so it doesn't line up because of the lack of population and the zoning there.
Right.
I'm
sorry, go ahead.
Okay, so with regards to LAP and the nuisance there, we looked at that, and it's a tourist destination. You're going to have high concentration of activity because of it being a tourist attraction. And it's an unusual tourist attraction. It's not your tourist attraction you may find, let's say, on Century City. It's not going to be the kind of tourist attraction you'll find perhaps with the proposal in Westwood, or what you may find on Third Street Promenade. This is a location where people come to relax. People kind of enjoy themselves. They're on the beach. We're talking about within a few miles of the beach. So you could attribute some of that activity to the kind of tourist attraction it is.
Right. No, I completely understand what you're saying. It just seems to me that, for example, we just had a case in Westwood where there are numbers for a reason. X amount of fast food on streets, you count these things. I don't know why we have a number that what you are allowed to have. Why do we even have the number if we can have 6 times that and then have it backed up by a bad police record and then still have a finding made that it's okay? I'm just curious. And that's a judgment call, like you said. I'm just not sure I would agree with that.
Okay.
Commissioner Margulis, Commissioner Walls-Morocco, I really appreciate your comments as a neighbor of this area in Venice, and I think what you're pointing out is one person's tourist attraction is another person's neighborhood. And in this case, where residential properties, certainly within the area of influence of this property, we need to take that into account. And I would request that you take up to the zoning administrators who you serve. They need to look at this neighborhood differently as a neighborhood. This is our neighborhood serving restaurant, entertainment. This is where we go as residents. It's not Disneyland, and it's not someplace that is isolated and separate from the residents. So please convey that to the ZAs. I have a couple of questions that I can ask them. One is about, in the conditions, the increased noise levels, and items H1 and I2. There seems to be a kind of overlay of what's technically feasible in terms of noise mitigation, and I'd like.
Excuse me, are you in the 918? Which one are you in?
I am on page 6. And this is the case ZA 2012-1770 CDPC.
Oh, okay, fine.
Is that okay? Am I in the right place?
Yeah.
Is this common? I'd like to know, is this boilerplate language, this unless technically feasible? It seems to me like it is in conflict with the spirit of the requirement for noise mitigation. How can you call for noise mitigation and then say it's only required if it's feasible?
Well, let's first be clear that this is about construction. Okay, so this is construction. Well, this is a construction mitigation measure, and so unless technically feasible, yeah, she can give some administrators actually. So, as I pointed out, this is about construction. That's the mitigation measure you're reading, and so it's not specifically related to alcohol, but the construction of the actual building. So I just want to be clear that that's what we're reading. And so these are prescribed conditions from the Building and Safety Department, and they've been tested. So we don't argue with their standard boilerplate language. We don't alter those.
Okay, so on the I2, which is not the construction, which is the actual operations, when it talks about operational, does that also include sort of patrons and activity? I mean, how is operational defined? Is that? Yes.
Commissioner Kevin Jones from the LA City Planning Department. As it states in there, it talks about hiring a noise engineer to measure the noise. So what they would do in doing their assessment about noise and whether or not it's spreading to the neighborhood, they would go to the site, and then we go to the neighborhoods and take measurements of sound levels to establish what the ambient noise level is. It is entirely possible that with construction techniques such as walls and applying attenuation materials, that based upon sound levels, there may not be additional noise to the surrounding residential areas. But you have to take the measurements first, even though that in the noise ordinance it does have certain levels, but you have to go out, measure the ambient noise levels first, establish what those levels are, then go through and do the noise checks at different hours of the day during the operation of the restaurant, and to determine whether or not where those noises are coming from. It's entirely possible that it may come from the site, it may come from other areas, and that's why they establish what the ambient noise is first.
Right, I understand why you need a baseline ambient noise level to measure against as a kind of criteria of a milestone. But you know, one question with that is that seemed, I guess, a question I have about the drawings that are provided in terms of the design of this facility is it seems a little bit cart and horse to me that you can show a design that you know doesn't look like it achieves the noise attenuation or mitigation that's required here, and then the process beyond establishing a baseline is go out and measure it after it's all done. It seems to me like we need to be a little bit more proactive, and if there's a mitigation requirement to make sure that operational sound shall be inaudible beyond the property line, you know, that we should be seeing some sort of evidence of that, or the acoustical engineer needs to be involved now in advance to make sure that that condition is actually implemented. So I'm hoping you're not going to tell me that that's a building safety review item and that we have to wait until they review that to know whether it's going to happen or not.
In preparing the mitigation, in preparing the environmental impact or the environmental assessment, these were the standard mitigation measures that we use. If you would like, as a commissioner or as a commission, would instruct us to prepare the sound test in advance of any construction, you could certainly do that, but that's not part of our normal mitigation measures that are part of noise attenuation.
No, I guess I find it as a...
And then remember, they're supposed to come back in 2 years if it's excessive, and then we can add more conditions to attenuate the noise if they exist.
But if I can't make a if I review the project and I have no basis for substantiating a finding that it complies with the noise mitigation, that seems to me like I'm missing a critical finding at this point. Okay. Last question is about the parking, because parking is what we usually spend all our time on. I don't know why we're talking about noise here. The beach impact parking. Yeah. Maybe I'm misunderstanding this, but it seems to me what I'm reading in there is that the project requires 2 beach impact parking spaces, that 50% of those spaces can be satisfied with in lieu fees, but it seems to be saying that one of them has to physically exist. I also read that there's no parking whatsoever for this project, but it has a credit of 7 spaces, but I don't understand where they come from.
And also, remember, a person may use bicycle parking according to the Los Angeles Municipal Code. So they can use 4 bicycle parking places to replace that beach impact zone, particularly in Venice where bicycle parking is allowed. Because here's the problem, one of the issues is that the Venice-specific plan does not address the fact that the municipal code allows for different kinds of parking. In this case, it allows for the applicant to access bicycle parking at the rate of 4 bicycle parking spaces for 1 parking space. So that would address that.
Where do those spaces do they need to occur on the property?
On the property.
And have they been shown? Has the location been shown for those?
I'm sorry.
Or the sidewalk?
No, there is a provision of the code that allows some parking, not permanent parking spaces for bicycle parking, but on off-site parking in front of this building. So you're limited though, but you can use the public right of way for bicycle parking, but not all of it.
So has bicycle parking in lieu of the required one each impact space been shown in the plans that we've been given?
Well, you see what happens in this case is that it has the credits, which comes from the fact that you have an existing building that was built prior to any parking requirements. The loss, once again, we get into the absence of any language in the Venice specific plan. You then default to the Los Angeles municipal codes that does allow for credits for an existing building of a certain size. You say that you have X amount of parking spaces. And that's really the biggest problem, is that the Venice specific plan, among other issues, does not address. And I think we tried to explain that on, and we will continue to explain that, because Venice has that problem. They're old buildings, and they have a credit because they were, of X amount of parking space because of the size of the building.
Commissioner Halper, this restaurant, according to its approved or its license, was a takeout, not a restaurant.
Well, remember, yeah.
We're now going from a takeout to a full service restaurant with alcohol, and there is no parking allowed there or possible, as I looked from a site visit. I look at, when you talk about in lieu fees, practically, in a recent case we discussed this, and I asked, okay, what's in that kitty? And they gave me the amount. I said, well, what will that buy? Based on a $50,000 price tag for a slot, and it was 16. The whole fund would fund 16 and a half slots at this point. It's not very, from a pragmatic viewpoint, it doesn't seem to me that we have a viable situation.
I understand your questions, Commissioner. However, remember, we're following the provisions of the specific plan as it's currently written. Until such time that the community, working with council office and getting it through council, and oh, by the way, the Coastal Commission changes the provisions and amounts, we as the planning department can only recommend what is in the specific plan. In this case, what we have is what we found is that the project as designed would comply with the provisions of the specific plan, if they use the variety of options that are available to them in not only just the specific plan, but also in the Los Angeles Municipal Code. By the way, you should know that the council office has been very active in obtaining the funds to fund the revision of the Venice specific plan at some point, but they have not gathered all of those funds. And then remember, there are a variety of different projects that are on the planning department's scheduled agendas for several years. And so the chances of Venice coming through, it will come, just not in the time period that we can consider this project.
Well, we're looking at this project tonight specifically.
And I understand.
And
We're here long enough.
my concern
But remember, it's within the existing provisions of the
No, I
specific.
understand. That's one of the reasons I understand our commission is a higher determination body in terms of this particular issue. But I do appreciate, the fact that you're trying to read the book as it's written.
Okay, Commissioner Donovan, just to help me understand also, you've limited the service area to 1,000 square feet. Is that both in the rooftop and inside?
That's correct.
And so, does that mean they can have 1,000 on the roof and 1,000 total?
It depends on how they want to configure the building, if they want to place all the service area on the top and having none on the ground floor, they could do that, but the maximum service floor area that they could have. But remember, the plans show is that a portion of the service floor area is to be on the ground floor. So if they were to change that, they would come through with a project, building permit to revise the plans, and that would be part of a director's determination to find that it is compatible with his determination or not. They could certainly come by it later on.
And how many seats does that get then?
The specific plan doesn't speak to seats.
No, but in terms of the conditions, you're imposing a 1,000 square foot limit on the surface floor area, right?
That's all that the specific plan can address. The zoning administrator's office probably could give you a seat count number.
Well, because I did see something in here about, where is it? 60 seats, 24 indoor and 36 outdoor?
Yeah, that would be part of the zone administrator's approval for the alcohol sales,
Okay.
and that they would be limited to a maximum of 60 seats.
I'm going to get confused because we're going back and forth between
I do understand.
two things here. So, okay, basically, they can get 24 indoor and 36 outdoor seats. That's what you've given them. Okay. And the hours you've given them are 7 a.m. to 10 p.m. Sunday through Thursday, and 7 a.m. to 11 p.m. Friday and Saturday.
That's correct.
Now, I guess in terms of noise attenuating features of the rooftop, I guess for me, looking at this particular case, I've become more concerned about the rooftop noise as opposed to the inside noise, which can be easier muffled. What kind of attenuating features are available to the rooftop that you're going to recommend or ask them to utilize?
There are walls that can be used, landscaping material that can be used. You attach them to an extent. You could also, depending on what the noise engineers determine, it could be covered.
And that'll be determined by building and safety?
Correct.
Okay. And also, you've granted...
building and safety in conjunction with the sound engineer.
Right, okay. And then you talked about the a plans review of 2 years, but you've given the authorization for the alcohol for 5 years. Any reason why 5 years as opposed to tracking it right along with the 2 year?
Well, the plan approval gives you an opportunity to review the project, and
Okay.
if for some reason they're bad neighbors, then you can have them consider mitigation measures, or consider conditions, I should say, to improve themselves as a neighbor.
So under the plan review, the 2 year plan review, the condition of the actually having a CUB for alcohol can be considered right up front, right then?
Well, for the most part, what we're looking at is making sure that all the conditions that we asked them to comply with are met. So that's really the basis of the plan approval. And so if for some reason that they are not meeting the conditions and they are bad neighbors, then the zoning administrator will probably take actions to shut them down. But this is really an opportunity to correct. We don't want to be punitive at this stage, but it's an opportunity to correct whatever actions. 3 years later, when they're filing for another grant, if they haven't corrected themselves in 3 years, then at that point they probably will not get another.
You said 3 years, I thought it's 5 years.
Well, 3 years after the 2 year of plan approval.
Okay, I see. Okay,
3 years to 5.
Sure. Okay. And okay, I think that's all I have. Any further questions for staff? Let's get going to the appellants. Ilan Morosi. Get your name, your address, and you have 5 minutes.
Hello?
We can hear you.
May I make a request, seeing as it's 2 cases combined, but I made an appeal on 2 separate cases? I was expecting 5 minutes and 5 minutes. Can I combine and be quicker than 10, but if I need a little more time? Just asking you in advance. I know you're very generous with the time anyway.
I'll tell you what, I'll give you 5 minutes and we'll see how it goes. If you really need a whole lot, I'd rather have you be concise as you possibly
For
can.
sure I will do that. Thank you. And now I've lost my place. My name is Ilana Morosi. I'm the appellant. 615 Sunset Avenue, Venice is my address. Where to start? We've, first of all, us with the orange sticker are all neighbours in solidarity of this. About 10 have had to leave earlier tonight, so I'll speak on their behalf as much as I can. There are obviously very big issues here. I'm going to start with the issues that I think are the most important. Just as confused as you were, Commissioner Halper, we're very confused as a community. We've noticed from the beginning of this there has been piecemealing of this whole case, and it's served to confuse us very terribly as a community. The project's been chopped into pieces so that their environmental review didn't come through us, and we've had two different sets of plans and two different sets of blueprints. What I've noticed is so what we've actually been doing, I think you've got the correct plans in front of you, which is the 2-story, but what we've actually been trying to come to terms with was that in one file, we've had this, the single level in the DIR file, and in the second file, which is the ZA and the environmental, the CEQA, we've had a 2-story. They're very, very different buildings. So as a community, we were never sure what was actually going to go, or what was going on. And as you heard tonight, the city actually wanted to put a stay on this and have the hearing a further time, but we're all here now, so thank you for hearing us. So essentially, we as a community were left out of this process from the beginning. It was never heard by the Venice Neighbourhood Council, even though in the zoning letter it was stated that the applicant would bring it to the Neighbourhood Council. We never got to look at it. So we never saw, all we saw were bits and pieces of these plans along the way. So it was run by the land use planning. As you can see, as neighbours, we're very concerned. That's why we've all turned up. It was run by the land use planning committee twice, and in their published notes, committee stated their concerns about lack of parking, the noise for the neighbours, traffic issues, and there was an actual draft motion to deny it because of all these issues. So I just want it to be on the record that the neighbourhood council and the community never actually got to have a say in this, and many of the neighbours were not adequately noticed about hearings, so we were never aware of exactly what the project was going to even be. Right. So I just want to get back to the actual specifics of the building. I believe we're talking about this one here, the treehouse one. This is the one, Mr. Jones, the agreed plans that are in the ZA file and the environmental file.
That's correct.
Okay. This is actually, in front of you here, is actually an artist's rendering of what the building is going to look like, according to those plans. And I want you to see, you've actually got a small copy of that one. That's how it looks, joining 15 feet across an alley to where there are residences. Those two little white buildings are actually 8 apartments. People will live 15 feet from there. So I would be wondering if you have a second story, potentially seating 60 people or more, because you can have the 1,000 square foot upstairs, and it's open, how is the noise ever going to be mitigated for those neighbours who live 15 feet away? And then we have more neighbours 50 feet, or less, 32 feet across the road. So whatever noise mitigation measures might be standard, I don't see that anything would be adequate if you are one of those poor neighbours 15 feet across the alleyway from that. They're operating illegally. I have a problem with the fact that this has been operating as a full sit-down restaurant for 5 years without permits. And
And I would very much worry if we have to wait another 5 years for a review to see if they're good or bad neighbours. They've already proved that they're bad operators and bad neighbours by operating illegally for 5 years. So that's a concern for us neighbours. Regarding the noise, I've actually got a noise expert, an audio engineer who's coming up to speak about potential noise issues. As you know, we have the LAPD who has weighed in to say that the alcohol in the area will cause a problem for the neighbourhood, and they're very concerned that it is going to be a really bad situation for the immediate neighbours. Regarding the CEQA was actually filled out by someone in the city planning office, or the zoning office. It didn't seem to have any independent reviews or any independent input. So, and the major issue with that is the parking and the noise issues. So again, I would like to know how that could possibly be mitigated. One other thing of concern which I'm going to address is about the floor area ratio. According to the Venice specific plan, the FAR has to be limited to 0.5 to 1 for retail only, which includes restaurants. So this actually is, as the property is now, it's pretty much built out to the property lines, the current business. So the expansion upstairs will certainly blow out the FAR limit, which is not, the expansion of the floor area isn't permitted under the VSP, Venice specific plan. And lastly, I'd like to talk about the parking issue. And again, according to the Venice specific plan, it does not, in the Venice specific plan, it doesn't allow for in lieu parking. I know in the DIR report, or the recommendation, he has said that parking can be in lieu for 18,000 per space. Actually, there is nowhere in the Venice specific plan that states that the regular parking spaces can be addressed by the in lieu remedy. So,
Okay, you'll have another bite at the apple at the end. Just a quick question.
and one more thing is, I also was told by someone in the building and safety that once a change of use is effected of a property, that the grandfathered spaces can't be carried over. So those 7 or 9 grandfathered spaces that they're hoping to take with can't be grandfathered once there is a change of use. So essentially, on the 1,000 square foot floor area, the applicant owes 20 spaces, actual spaces, and also the 2 beach impact zone spaces. So that's 22 spaces, real, actual, physical, tangible spaces that need to be found, because the Venice specific does not allow you to buy them off with an 18,000 in lieu.
Question, Commissioner Halper. I'd like to make that question to either of our staff, our planning staff, either, anyone there. Is that true?
I'm looking for those commissioners. Kevin Jones looking for that one.
While you're looking for that, I have a question for the appellant. Ma'am, that's okay. You said the restaurant's been operating for 5 years without permits. Have there been any kind of specific nuisance activities that have been occurring because of this restaurant?
I believe they have had violations reported against them.
Not just violations, I'm talking about things, how have they disturbed the neighbors?
I think a neighbour will want to speak on that. I'm not one of those immediate neighbours across the alley, thank God.
All right, I'm just
I
asking
think
you.
someone will address that.
And if anyone wants to speak, you fill out a speaker card, we'll call your name, you'll get your shot. Okay, now, if for some reason the commission is inclined to grant the CUB and all that, are there any particular further conditions you would like imposed?
Well,
I'll tell you what.
that's a bit of a loaded question
No,
because
it is.
my
It is a loaded
answer
question.
is we don't want alcohol. Well, it's not about the alcohol. There is obviously a very high concentration already in the area. And I'm not opposed to people drinking. It's about what comes with it. It's about the noise. It's about people living 30 feet, 15 feet, 14 feet from there and having their lives disturbed day in, day out. So even if you said stop serving alcohol at 10, people will sit on the rooftop till 1. And the way the noise carries, I just don't see.
So shorter hours would be something you might be interested in?
Well, I honestly, I still think that having 100 people on your rooftop at any hour of the day would be a challenge to
So I
live
think
with.
they're being limited to 60 seats total. So,
Well, they in theory,
okay.
but they
All right.
have 1,000 square feet to fill. So
Okay.
there is also a bar as part of it, so people could possibly stand at the bar. If you say 60 seats, that's literally 60 seats. If you have people standing around at a bar, that could be an extra 20, 30 people.
All right. Well, you get a chance to have a rebuttal, and you might think about conditions to be imposed during that time when you get your step up. Okay. All right.
Commissioners, Kevin Jones from the LA City Planning Department. Section 13C of parking provisions for the specific plan does allow for the purchase of parking spaces. To provide in lieu payment fee in the Venice Coastal Park for any deficiency created due to the change of use. The permits that are on site indicate that it is a different use, and they're changing it to the restaurant. So that is part of the issue here. They're correct. It's not an allowed use, and they're converting the use from and there is a certificate of occupancy that says that converted the existing repair shop to takeout, restaurant within 1 story. They're going from takeout to restaurant, so that's a change of use.
So in other words, you're saying that they would have to provide more parking? Does that make your conclusions, either of your conclusions on the...
Not to the amounts of the calculations that they can do, because remember, they can access the bicycle parking, they can buy out a portion, and they have non-conforming rights. And here's the thing. The real issue goes to how much the building are they going to remove. Because they can certainly use what people view as walls are not what walls of building and safety uses. They could certainly remove all the drywall, all the stucco, any siding. What remains are the studs, the sill plates, and the headers, or any windows. That's what comprises a wall for building and safety purposes. So you could take everything down. You could even add more supporting studs to support that. And that's where it gets more difficult to comprehend, is that people go around and they say, well, it's a whole new house. They tore down everything in the structure. Yes, they did, but the state of California and the Department of Building and Safety have definitions about what walls are.
Commissioner Hopper again, but that's not the issue. The issue is change of use, not of structure.
Right, but I'm just introducing that as well.
The Venice specific plan has
Sorry.
Go on the mic.
You'll have to get another chance, but you have to also speak into the mic at all times, because that's being recorded.